So thank you very much for joining this, our second in the series of webinars being delivered by Garden Court Crime Team. And we're exploring the position of children in our criminal justice system with a particular emphasis on the challenges being posed by COVID-19. You will have noticed that when you arrived in the Zoom call that you will have been muted and you are unable to unmute yourself. We will be having a question and answer session at the end of the seminar. If you do have questions, please post them in the chat window, and so that the speakers will be able to respond at the end of the seminar. You may find it helpful to have your camera on speaker view for the presentation. The presentation slides will be circulated to all registered participants, and the webinar is being recorded. What this means is that audio and video of anyone who speaks will be recorded, and this recording will be shared to participants at the end of the webinar. No other audio, video or personal data will be recorded or shared. So today we are very lucky to have Michael Gould and Audrey Sherrill-Mogan, who are going to be speaking to us today, who are both barristers at Garden Court Chambers. But we are delighted and privileged to also be joined by Dr. Laura Janes, who is the Legal Director at the Howard League for Penal Reform. So we are going to start today with Dr. Laura Janes, who is just going to give us an overview of conditions and the position for children who are in the secure estate at the current time during the coronavirus pandemic. So I'm going to turn now to Laura Janes. Thank you.
Thank you very much, Kate, and thank you very much for having me. So just by way of introduction, I'm sure many of you are familiar with the Howard League for Penal Reform, but I'm afraid I have to remind you every time that the Howard League, of course, is the oldest penal reform charity in the world, set up in 1866, and it works generally for less crime, safer communities, and fewer people in prison. It tries to do this through a combination of policy, research, and direct legal work. And our direct legal work, I'm the legal director of the Howard League, is in respect of children and young people aged 21 and under in custody. We run a confidential legal advice line service, which is on the pin of every young person in custody. So they don't need to get approval to call our advice line. They can get straight through to one of my lawyers. It's a free number and it's confidential. It's open every weekday morning. And we have, with some effort, managed to keep that service open during the COVID pandemic, and we're running it all remotely on a rota, and we are sadly as busy as ever. I'll come back to that in a moment. We also provide an access to justice service for professionals, so any lawyer, yacht worker, social worker can call and talk through particular cases and issues, and we have expertise in issues such as community care for the rights and entitlements of children and young people leaving custody, as well as parole, adjudications, criminal appeals and other such things. But really I'm here today to talk to you about the state of prison for children generally, and in particular at this time during the unprecedented COVID pandemic. There's lots of information on our website, and our Twitter feed is very regularly updated. So who are the children in prison? Well, I'm not going to read to you this entire quote here, but it comes from James Mumby in the case that founded the Howard League that founded the Howard League Legal Service, and it's a description from 2002 of the children in YOIs. You can see from that half of the children in YOIs had been in care. They came from extremely disturbed backgrounds, often with lots of experience of violence, neglect and abuse. And the reason I point this out to you today is because, very sadly, the picture just hasn't changed. You can see that the latest data from the Youth Justice Board official statistics, which looked at the characteristics of children coming into custody between 2014 and 2016, found that in a third of cases there were serious concerns about suicide or self-harm, physical health. And I just focus on that now because in this time of serious health crisis, to think that 30% of children coming into custody have identified physical health concerns is clearly very, very relevant when thinking about the risk and COVID. And of course, lots of concerns about mental health. The other key thing to remember, of course, is that the proportion of children in custody from Black, Asian and minority backgrounds is much, much higher than in the community. And that's a picture that's changed. I'll come back to that over a moment. And at between a third and a half of children in custody still report having experience of the care system. Now, you can see here that there has been a reduction of a significant number of children being incarcerated generally. So when I first started doing this work about 15 years ago, there were 3,000 children incarcerated at any one time. Today, the number is significantly under 1,000. But what you can see from this chart here is the reduction has been largely in the number of white boys. So this is the light blue line here, and if you look at the dark blue line, which represents children from minority backgrounds, you can see that the reduction has been very slight, to the point now where a decade ago, a quarter of children in custody were from BAME backgrounds. Now it's around half. And that's something that was highlighted by David Lammy in his report in 2017. And since then, the situation has become worse. Now, when it comes to children on remand, we have an even more acute picture. The first thing to always remember is that 2/3 of children, this is according to the Youth Justice Board themselves, 2/3 of children who are remanded to youth detention accommodation don't go on to get a custodial sentence. And although I said that the proportion of BAME children in custody generally was half, when it comes to the remand estate, I've just had a Freedom of Information Act request responded to, which shows that in the southeast, if you look at the YOIs, Feltham and Cookham Wood, you can see that in fact 2/3 of the children there pretty much are from minority backgrounds. So it's extremely, it's extremely disproportionate, particularly in the southeast. The other thing, of course, to note is that proportion of children within the estate who are on remand as opposed to sentence is increasing. It used to be around a fifth. It's now an all-time high in terms of proportion at around a third. So although the use of remand was supposed to be decreasing, it has in fact increased in recent years. Now, I'm sure many of you will have heard about the disturbing conditions that children are held in generally. So I don't want to go into all this detail. You have the slides here. But we know that there are extremely high and increasing levels of the use of restraint and self-harm, and that has increased even though the number of children in custody has decreased. Still, between 30 and 40% of children in custody do not feel safe. And there's been a huge flurry of concerns from medical professionals, expert human rights bodies, and the inspectorate about the risks of the many children who are held in solitary confinement. Although we will come back to that because, of course, that has now become the norm for all children, at least in YOIs. So since the COVID-19 pandemic commenced, and since the 24th of March specifically, in line with government policy, all prisons, and I'm talking really about the YOIs here, and pretty much the STCs, have had to institute social distancing, a term which, in fact, is a bit of a misnomer, really, but effectively restricted the regime within prisons to the point where children cannot be together and staff cannot have one-to-one contact with children in a meaningful way. That means that every child that we've spoken to on our advice line YLY in the last couple of weeks has described, and I've spoken to 3 children this morning who've said exactly the same, that they are now spending pretty much 23 hours or more alone in their cells every single day. I asked a child this morning how he felt, and he just said he is so stressed. It's just constant behind your door, no education, no face-to-face visits. All the children are getting in the YLYs are some worksheets shoved under their door, which are not tailored to their age or stage of education, their level of need, no support with it. It takes them between 20 and 30 minutes to complete. No therapy, no group work. The health and wellbeing teams, if they can visit, have to visit possibly once a week and speak to the child through the door. And of course, that means that if they need to have interaction with their social worker or with their lawyers, the only means is by way of video link, and that makes assessment very difficult. Now, to help you with your bail applications, which we're coming on to very shortly, the Howard League has produced a 2-page briefing. It's really tight with all the key data and up-to-date information so that you can actually use that in court. It's available on our website, and if you want to be able to say to the court, remanding this child is remanding this child to solitary confinement, we've put this together so you have the evidence, as it were, to point that out. Okay, and at this point I will hand over to Mike, who will take you through some of the legal framework for youth detention.
Thanks, Laura. Yeah, so I think the way we're going to divide this up is I'm going to talk a bit about the legal framework, the law behind youth bail and youth detention, because the law itself hasn't changed under the coronavirus. It's just the practical circumstances that have. And Audrey, I believe, will speak a bit more about the practicalities of making a bail application under these circumstances. So let's see if I can share my screen without doing something awful. I hope that's working. Right, so yes. Basic principle behind the legislation governing youth detention is that, of course, children and young people should be detained as rarely as possible and for as short a time period as possible if they are. And the domestic legislation that we have that enacts that reflects international obligations and treaties that we've signed up to as well, most notably perhaps the UN Convention on the Rights of the Child. So Article 3.1 of that convention requires that in all actions concerning children, bodies, including courts of law, take into account or in fact make a primary consideration of the best interests of the child. Article 37 includes the requirement that no child shall be deprived of his or her liberty unlawfully or arbitrarily, and that any detention must be a measure of last resort and for the shortest appropriate period of time. Now, those international obligations are reflected in domestic law in a number of places, but one of the ones that comes up most often perhaps is Section 44 of the Children and Young Persons Act 1933, which isn't quite as strong as Article 3 of the UN CRC perhaps in terms of primary consideration, but it requires that courts will have regard to the welfare of the child or young person. About as strong as it gets, unfortunately, for criminal legislation. Stronger in the family courts, of course, where it must be a primary consideration. And Section 11 of the Children Act, which places a duty on the police and other bodies to make arrangements to ensure that they can discharge this duty to have to promote the welfare of children. Something that might be useful as well if you're making a bail application, it's not strictly applicable, but is the youth sentencing guidelines, which, again, dealing with sentencing, but give guidance on how this sort of legal principle is carried out in practice. And it notes that it's important to, of course, avoid criminalising children and young people unnecessarily. I like the use of the word unnecessarily there, as if sometimes it might be necessary to criminalise a child, but there you go. but that's an argument for sort of avoiding custodial sentences, that you could also avoid, remand in custody to keep children away from criminal influences in that way. And it notes that custodial sentences are a matter of last resort, but of course the same should be said for remands into custody. So those are the overarching principles. Bail, well, the first place that bail is considered isn't, of course, in the courts, but it's in the police station when someone is charged. The test for bail is the same in the police station as it is in the courts. Largely, the objections to bail are the same. Some provisions specific to youths in relation to police bail. Section 38 of PACE requires that when a youth is remanded into custody by the police after charge, they must be transferred to local authority accommodation if they're going to be there overnight before being produced in court. Unless, that's a must requirement, unless a custody sergeant certifies it's impracticable to do so, or the child is 12 or over, and the custody sergeant believes that secure accommodation is required because of the risk they propose and it's not available. Now, in reality, that requirement is breached constantly. It's by far a rarity to find a youth that has in fact been transferred to local authority accommodation after police remand rather than kept in the cells overnight. But that's supposed to be the starting point. Section 21 of the Children Act creates a parallel obligation on local authorities to accommodate such children that are referred by the police in that way. But it is routinely breached. Two interesting cases here. Crown on the application of M versus Gateshead Council sort of watered down that Section 21 obligation on local authorities, saying, well, actually all the authorities need is to put in place a reasonable system to deal with requests. It doesn't mean they have to satisfy every request if their system is reasonable. And just the sort of low bar the courts will set for what is reasonable is indicated by the more recent case where a young person was, police actually made a request, which might itself be a rarity, for secure accommodation. Local authorities said, sorry, we don't have any available. And the child was kept overnight. Decision of the local authority was JR'd. And it turned out that of 17 recent requests for local authority secure accommodation from the police under Section 38, not a single one had been accommodated. And the court nevertheless found that the system the local authority had was reasonable. And it's pure lack of resources that we see here, because the local authority doesn't have, in this case, Waltham Forest doesn't have a secure accommodation unit. So like most local authorities, they sort of buy into a network where beds are shared and there just aren't enough beds. But the court said, well, what else is the local authority supposed to do if they don't have their own beds? That's a reasonable system given the lack of resources, which is quite depressing, but there we go. But the debate, it should be that they're going to local authorities. It just, rarely happens with police remand. Court bail after the police remand, of course, that would be the next time it's dealt with. The starting point is the Bail Act as it is with adults. There is a presumption, of course, in favour of bail, apart from the certain limited exceptions for murder and certain serious sex offences when one has previous convictions, as with adults. The objections to bail are largely the same: commission of further offences, interference with witnesses, and failure to surrender are the main ones. The most significant distinction is that a child can be remanded in custody for their own welfare, whereas for an adult, the test is for their own protection. So that's a slightly lower threshold. Some other youth-specific factors are that in terms of conditions that can be imposed on bail, a parent or guardian can be asked to stand surety for actually ensuring the youth complies with conditions rather than just attending court, which is the only way a surety can act for an adult. There's also limitations on whether a youth can be put under electronic tagging as a condition of bail, and those conditions are set up there on the slide: age 12 and over, imprisonable offence, violence, sexual terrorism, etc. And one other useful thing to know, it's quite well known at this stage, but always a good case to have at your hand, is that the High Court, in the case of Brent, Crown on the application of B, Brent Youth Court, found that young people, the fact that someone's a youth and that requirement to take into account their best interests or the welfare of the child may justify more than the usual one bail application you get in the Crown Court or two in the Magistrates' Court. You can argue for additional ones. If a child is not granted bail and remanded, the starting point is it should be to local authority accommodation. So it's not custody, they are just accommodated as directed by the child, by the local authority. And this is dealt with at sections 92 to 97 of the Legal Aid, Sentencing and Punishment of Offenders Act. The court designates the local authority in particular, which is usually the one that's sort of, if it's a looked after child, the local authority that's already looking after them, if not, the one the child lives in generally. And a child who is remanded into local authority care or into custody becomes a looked after child. If it's not local authority accommodation, it will be to youth detention accommodation. This is dealt with at sections 98 to 102 of the LASPO. So this is secure accommodation. This is effectively youth custody, which can be a secure children's home or training centre, or can be a YOI. Now, this is a slightly complicated area. It's basically, there's a flow chart at the end of these. It's always useful to have at the end of these slides that you'll get when they're sent out. But effectively, there's two sets of conditions that must be satisfied, either set, for a child to be capable of being remanded to local authority accommodation. It's still a discretion if those are satisfied. Both sets of conditions require that the child is at least 12 years old, that they're legally represented or would have been but for their own behaviour effectively, and that the remand to youth detention accommodation is necessary to protect the public from death or serious injury caused by the child, or to prevent the commission of further imprisonable offences. They're then separate elements of the sets of conditions. The first set require what were known as the offence conditions, require that in addition the offence is violent, sexual or terrorism offence, or is punishable an adult with 14 years custody or more. The additional conditions under the second set, known as the history conditions, are that it appears the child would get a custodial sentence if convicted. The offence is imprisonable, and effectively the child has a recent history of committing offences on bail or absconding. But again, it's important to remember, that's the flowchart I was talking about, it's important to remember, particularly in the current circumstances, that even if those are satisfied, it's a discretion. The court doesn't have to remand to youth detention accommodation if those are satisfied. Now, very often perhaps they would in the ordinary circumstances, but if there's ever an important factor bearing on that discretion right now, a relevant factor to take into account, it's what Laura has just said about the fact that a court will be remanding a child into effectively isolation. The conditions of the prison, the current custodial estate for youth, must be a relevant factor in exercising that discretion. But that is a quick fly through the legislative framework. That is the flowchart that I've talked about, which is hopefully quite helpful. But you may well have seen it before. It usually does the rounds. It will be in the slides that get sent out to you after the talk. And with that, I think I'm going to try and stop sharing my screen and hand over to Audrey.
Thanks, Mike. Okay, I'm just going to try this sharing screen thing myself very quickly. Yes, I think that's worked. So I'm just going to go quickly through some of the things you might be able to use in bail applications very quickly before I hand it over to Laura again. I am sure that I don't need to tell the people, participants in this webinar, about the shambles that young offenders institutions inevitably are. I mean, from 2010, the then Chief Inspector Nick Hardwick published report after report detailing the issues of violence and self-harm, and at that time even the prolonged confinement of children in young offenders institutions. And of course, when he didn't reapply for his position, he cited what he called, prison horror fatigue, basically becoming desensitized to things that objectively, when you're looking at the prison system, you should be shocked at. But then, of course, his successor in 2017, Peter Clark, went on to still say, that there is no safe space really for young people in prisons across England and Wales. And we know, of course, as recently as last year, the real decline and the surge of violence and self-harm in Feltham is still being felt. So this is an issue that doesn't seem to be going away. And of course, let's see if I can change my slide. Oh, 1 second. There. And of course, this is something that's, these are issues in YOIs even before COVID. Now, Laura spoke about this, but there's 293 children currently on remand, and that is an all-time high in terms of remand. And that's really worrying when remand is supposed to be used for children as a measure of last resort. She spoke about the reality on the ground, which is the solitary confinement, 23 out of 24 hours for children, no face-to-face visits, and no constructive activities around education. And I combined that with what would be the inevitable increase in violence because the reduction in staffing, prison officers, then they themselves self-isolating, people getting sick, combine these things together. And that level of violence, of course, it doesn't take a genius to figure out that it's going to exacerbate all the problems that were already prevalent in young offenders institutions all this time. So Mike referenced this already, but the Brent Youth Court case is such that there's an argument to be made that multiple applications for bail for children can be made in any event. But of course, it's coronavirus, and this is a worldwide public health emergency. It's not an exaggeration to say that everything really has changed. These are very clearly a change of circumstances. And that's, I believe, recognized by everybody in the criminal justice system because everything we've had to do and the way we work has completely changed. So we suggest, of course, that renewed bail applications should be made for all children, child defendants. And I just highlighted a few key points on this slide that could be drawn out in some of those bail applications or renewed applications. Now, the first point I'm just going to look at is the fact that this indefinite delay of trials. Now, even before COVID, we knew that there was a huge backlog in trials, especially in the Crown courts. I was getting cases where people were on bail, but you were having warrant list cases before COVID for 2021. So it's clear it's only going to be a bigger problem now that nobody is having trials, both in the magistrates and the Crown Court. Now, of course, there's discussions around the common video platforms and remote trials, and obviously that's outside the remit of this discussion. But of course, real scrutiny needs to be given to how young people and children and vulnerable children are going to really be impacted by that. But the reality is this, that we have no idea when trials are actually going to resume. Custody time limits are being extended, and effectively what this means is that children in youth detention centres are basically being detained indefinitely. And that kind of uncertainty, even for an adult, is going to be problematic, but that kind of uncertainty for a child is going to be hugely detrimental to their mental health. And that's really important to remember and to raise when you're making those applications. But it also means that there is a real risk that the children will be spending more time serving a longer time awaiting their trials because of this uncertainty than they might even get as any custodial sentence. And again, that should be highlighted. And how any of this can really be in line with our domestic and international obligations, as Mike set out, for measures of what should be last resorts and considering the best interest of the child, is really problematic. Now, I'm just going to skip the restrictions on movement for a second and just move to my second point first, which was the inadequate prison conditions. Now, again, this is something I'm sure everybody knows, but it's something that I think when you're making these bail applications, it needs to be highlighted over and over again, because I think there's a real disconnect sometimes with magistrates. Look, it's youth courts that you might be making these applications sometimes, but in any event, they're treated sometimes like magistrates. Just go quickly, do everything really quickly. And you need to really highlight these points about the overcrowding and the unsanitary conditions. And also, we do know that generally the health of people in prisons, maybe those exposed to prolonged drug use, that generally in prisons, the health is poorer than that of the general population. And during an international public health emergency, that's something that's really important that should be highlighted. I think I just read recently, I think today, something came out from Public Health England that there was some suggestion that almost 2,000 prisoners currently are showing symptoms of COVID-19. And that's really, really worrying in an estate that's already has a lot of problems when it comes to sanitary conditions. So the risk of contracting coronavirus whilst on remand just cannot be overstated. Then I've already spoken about this briefly, but it's that risk of increased violence. Again, the reduction in staffing, the lack of constructive activities, and lack of face-to-face social contact with family members. And then, of course, again, Laura's already mentioned, which I've just said, which is education and training and activities. I keep saying this, but it can't be in the best interest of a child to be remanded in these kind of conditions. And then just on the point of restrictions of movement, businesses, restaurants, pubs, I mean, they're all closed now, right? I mean, even in our parks and outdoor spaces are closely monitored. So it might be a point to make that children who are given bail in these circumstances are actually going to be given bail with a reduced risk of committing further offenses, because we're all monitored more closely. There's so much more restriction on all of our freedom of movement and liberty. And that should be considered in terms of, are they going to commit further offenses? Can they really be going out? And failure to surrender. And then kind of finally, just the trauma that children might feel. Everybody is scared, especially if you've got elderly relatives, relatives with who are already of ill health. I think it's really important to highlight that trauma that they're going to feel separated from their families, and not really knowing if they're going to get to see their elder relatives again. I think these are just kind of important things to kind of keep making, points to keep making, so that you keep reiterating the importance of how different this time really is, and that very acute, very specific impact it's going to have on children, more so than adults, but very, very specific in terms of children. Now, I know, I've made bail applications in the youth court, and I've kind of said it already. Most of the time, you just want to get in there. These are the facts, this is the law, be quick and get out of there, and that's kind of what youth court magistrates want as well. And we tend to kind of dodge getting involved in kind of like policy issues or making these points. But I just think it's really important at this time of international, public health crisis to highlight that the consequences for young people who are remanded at this time are particularly grave, and that it really needs to be considered properly before they're remanded. So just my next slide is just some of the kind of questions you might want to consider when you're taking those instructions. And of course, I'm sure all of you know this already, but even things like underlying health issues that maybe pre-corona might not have been that necessarily a big deal, things like asthma and stuff, but these are respiratory illnesses now. And it's just important to highlight that, of course, pre-existing conditions are only going to make you much more vulnerable when in detention. Also things like mental health issues. Now, again, of course, the participants on this webinar are going to be good at getting that information, asking those questions. But it's important, I think, to tie that into, again, what Laura has said is the reality on the ground. So it's not just XY young person has ADHD or Asperger's, any of those kind of issues. But it's also that now knowing what we know about the reality and how much they're locked up and their lack of education, how much more that's going to impact young people with mental health issues. And then, of course, asking about family members, because again, those people are going to be quite at risk, and that's going to cause a lot of trauma for young people. And then there's also the fact that they can be managed in the community. I've already kind of mentioned that in terms of we're all under lockdown now, and how to think about that. Now, I've mentioned the regulations here. Now, they don't directly apply to young people on remand, but I just wanted to put it in there because releasing prisoners, that being something that the government is contemplating, is doing, is something to point to say that the government has acknowledged that there is a strain on the prison population. There is a strain, and that is something that should be properly considered when a court is deciding whether or not to remand a young person. Now, in terms of local authority accommodation, now Mike's already touched on that. There's a real difficulty because there's issues around resources. They do lack resources, and it's difficult to kind of pinpoint what to do. And sometimes I know in my own experience in the youth courts, it can be quite a circular argument. You can't get a magistrate to grant you bail unless you have an address, and you can't get an address unless you get a direction from the judge. And you go through this circular argument, and it's whose responsibility is it? And I just think, apologies, that of course youth offending teams do have a duty to come up with that bail package, but we also need to look at how we can engage with them beforehand, especially now with a lot of the remote hearings, how we can get in touch with them beforehand, suggest what might be possible, suggest, including things like even extended family members out of the local area, just working together, because it is going to be a difficult time. Youth offending teams, of course, still working, but young people who are arrested and then coming to court are not going to have the same amount of ability to really be able to end up trusting, working with those youth offending teams, because we're all trying to work remotely. So I think just considering how we might be able to creatively work with youth offending teams, recognizing that everybody's got an issue with resources, but again, just really hitting home the importance of bail and not remanding young people. Now, just before I hand it back to Laura, I just, it's always important, I think, and Laura mentioned some of these, but just the real mind-boggling statistics that are the Black and minority young people in prison. Now, it's 51%. Now I put 2019, but that was actually the snapshot in January 2019. So that was more than half of children in custody were Black and ethnic minorities. But of course, over the 2018-19 year, it ended up being about 49%. And that is despite making up only 14% of the population. Now, that is incredibly worrying. And just again, from my own experience, I was just going to reference something in terms of the gang matrix, which kind of came out, some of the issues around that came out a couple of years ago. And it's a really racially discriminatory system, stigmatizing basically young Black youths for things like what they do on their social media and the kind of music they listen to. And, of course, the Met Police were saying it's a vital tool to fight violence. But I've seen myself and it becomes really problematic when this kind of police intelligence is used to suggest that a young person should be remanded for their own safety, for their own protection, for their own welfare. Because it becomes difficult to argue somewhat against that, because unlike their usual suggestions about why people should be remanded, which are always negative things, this is, well, okay, for their own safety. Now, how do you, as a defense practitioner, argue against that? And I think it's just really important to really scrutinize the evidence that's being put forward to suggest that this young person is at risk because of gang violence, and what other options are there in terms of housing them with extended family members out of the local area. Because it can't be right, especially now. I mean, never really, but it can't be right that especially now in these times with what we know, that really it is in the best interest of a child to be remanding them, even for their own safety, because of what we know, what is actually happening and the lack of safety in the youth offending institutions. Now, we all know about the Lamb Review, I'm sure, and the statistics that came up about that. It might be a very bold submission to try to make these points to magistrates, to highlight the real disproportionate impact, the disproportionate amount of BME kids that are remanded. I mean, it's almost like you're suggesting, watch out, I'm watching you be racist. But I think there are some important statistics there that need to be considered. Yes, so before I just hand it over to Laura, just to say that a number of our colleagues in the crime team have put together a really good protocol, not just for children, but adults as well, in terms of bail, which you can find on the Garden Court website. And of course, Laura and Kate have put together a really extensive guide about young people. So I think the combination of those two can be used to really make very strong bail applications for these children in custody. So thanks, Laura. I can hand it over to you.
Hi, thank you so much, Audrey. I was just going to finish up now with a little bit on that last very important part that you mentioned in terms of making sure that there's somewhere really safe for young people to go, because obviously we've heard in the news all sorts of curtailments to people's social care rights in response to the coronavirus. But I think it's really important to remember that the rights, the core rights and duties that exist under the Children Act 1989 are largely intact. There has been actually in the last week some secondary legislation that's been passed reducing the face-to-face visiting entitlements, but the duty to assess children who are in need of support from local authorities, who are not going to be able to develop or further develop without support from children's services, and also the duty to provide children who require accommodation with their agreement or their parents' agreement if they are under 16 is alive and kicking and absolutely still good law during this time. I'm not going to talk you through it all here because I think the point is just to know that it's there. I do want to distinguish it, of course, from the bail package that the youth offending team has to give. The bail package is the supervision and some support. Youth offending teams do not have a statutory duty to provide a roof over the child's head, and that often, as Audrey I think just alluded to, can be the huge problem. A young person, particularly if they've got exclusion zones or if they've offended in their home local area, they may need accommodation and support out of the area in order for the court to be satisfied that they can meet the criteria for bail and exercise that right to bail. So I've put up here for you some sort of key resources. It's one of our core pieces of work that the Howard League does, and of course Garden Court also has a really thriving and brilliant community care team. But you can see here, I've just given you our resettlement handbook, which was written I think back in 2014, but it's still good law. And we've also produced here a new step-by-step guide to supporting children from custody in the community, and that has really kind of I hope helpful templates, flowcharts where you can look, and you can even go to the section about children who are on remand in custody and follow the templates and flowcharts through. We've also produced, as Audrey has just mentioned, and it's on the Howard League and I think the Garden Court website, but will be made available if not very shortly, a joint sort of quick guide for you. And I'm just going to see if I can show you that screen. I'm not sure if that's working now, but you can see we've produced a guide here, which is to help you end the detention of unsentenced children, and it really covers lots of the stuff that we've talked about today, and including securing an effective bail package. And if you whiz through to the end, you'll see that we've given you template letters that you can actually use, and emails that you can send to support that. So I'm just going to go back to the slides. So what do you do then if you have a child who you're dealing with on a bail application who, but for somewhere to live and some support, or maybe some wraparound support in the home address if mum is poorly or dad is poorly, possibly with the virus? Well, you can write to the Director of Children's Services. Anyone can do that. It doesn't have to be a particular person. Anyone can ping an email. And here's one of my favourite websites of all time. What you can see here is it's the Association of the Directors of Children's Services. Every single borough in England, Wales is slightly different, but every single local authority in England, and you've got the name and the address and the phone number and the email of the Director of Children's Services. And in that guide I've just shown you, there's very simple template emails that you can use to put them on notice that this child needs accommodation and support now or whenever your bail application is. If you don't get any movement, it's quite often a good idea to be really clear about time limits there. Then of course the young person can get a legal aid lawyer to open a community care case. Legal aid still exists for that, one of the few unscathed areas. I mean, it's not megabucks that we get paid, of course, but it's there. And of course, that opens up the opportunity to threaten judicial review if that becomes necessary. And if you want help in terms of finding a community care solicitor, if that's not something that you have in your own firm, obviously if you've got your own community care contract, you can use it, but you can go to the Law Society website, and you need to, just a little trick here, is you need to go to social welfare and then community care. Legal aid is a subcategory, and you can find legal aid lawyers who do that work through that method. Or we also set up a specialist website for community care lawyers for children and young people. And we actually have an email list where we can share urgent referrals and make sure young people are represented when it comes to that. So that's very much a quick kind of opportunity just to flag that last sort of bit of the jigsaw to make sure that no child is remanded but for want of accommodation and support. The only other thing I'd just like to flag, of course, that Mike mentioned, is that any child who then does become remanded will, as a matter of law, become looked after. And of course, that in itself could be a change of circumstances and open up a whole new world of rights. And that's dealt with in our briefing. So, the fact of remand in itself might open up a change of circumstances. And before I close, I think you'll have an option at the end, but I keep this on my desk. And I'm going to say it now because I know Kate's very modest about it, but I'm going to just turn the angle so you can just see how enormous this book is. But it is the most comprehensive guide to youth justice and law, with a huge chapter on bail and remand. And I think there's also, and Kate is one of the three brilliant authors, and I should disclose I'm chair of LAG, so I have a slight vested interest in promoting this book, but it really is an excellent resource. And I think there's, Kate can say more, but I think there's a discount available to delegates of this webinar. Thank you.
Thank you, Laura. In fact, I think if you turn to the next slide.
Oh, yeah, I will reshare my screen. Yes. And then,
as if by magic, there is indeed a discount that is available to attendees on this webinar, and that will be circulated at the end with these slides in an email that you will receive from Garden Court.
And a link to the new pack as well.
Yes, and a link to the guide that Laura and I have been working on, just to take you through the law and guidance. So the reason for bringing these speakers together and to talk about this issue is that we recognise that because of the uncertainty around the resumption of criminal trials, the children who are currently remanded in the secure estate, or children who are being remanded, who are arrested during the pandemic and during this current period of social isolation, are facing uncertainty around when their detention might end. And we wanted to explore what ways in which we could support bail applications for children. And it's really important what we've heard from Laura about what the reality is for most children day to day who are remanded to youth offender institutions. I have had a couple of questions come in, so I'm going to turn to those questions. And I have a few questions that I might like to pose of my own. So the first one is, has anybody, this comes from Jude Lunchin, has anybody made a successful bail application in a serious case using COVID-19 arguments? Jude currently has a 15-year-old in a secure training centre. I can say, if I may, that I know of a couple of cases of serious children facing attempted murder and murder who have made successful bail applications since the pandemic, and they were cases where there wouldn't have been an expectation that those children would have got bail before the pandemic. But I'm afraid, aware of the exact arguments raised. Maybe I can turn to the other speakers if they've got any other examples to share.
No is the answer. I've made a few. I haven't won any yet. I mean, I have to say my personal experience is that courts are being very open at treating the coronavirus pandemic as a change of circumstances, allowing further bail applications if the defendant has already used up their usual allotted amount. It's a change of circumstances. I mean, some courts have actually put out circulars confirming that. And the couple that I've done, it wasn't even raised as an issue. We just put in an application and it was listed, and no one at any point questioned whether there was a change of circumstances. So that's very easy. Having said that, the question of then getting bail has been more difficult. I've got a bail application for a youth in a kidnap case coming up on Friday, where his co-defendant has already been granted bail in circumstances I wouldn't have expected. So maybe after Friday, I'll be able to give a more positive response. But yeah, my experience so far is much easier to get them listed as a change of circumstances, but not a wholesale change of the approach to granting bail.
I have another question around this. One of the issues touched upon, and maybe Laura, you can respond to this, is that children, we know that there are disproportionately high numbers of BAME children in the secure estate, and particularly those figures are worse in London and the southeast. And we also know that the disproportionality is higher in the remand population than the sentence population. Audrey touched upon one of the explanations for that is that the bail is being refused for the child's own protection. The risk that the courts are seeking to refuse bail because they think it's for their own welfare. How do you think courts will now respond under the current coronavirus pandemic?
I mean, certainly I think that the notion of remanding a child, and actually it's a big issue for women as well. Lots of women are remanded for their own protection, but remanding a child for their own welfare in 2020 is really, in my view, an outdated notion. As I mentioned, there's a huge array of provisions out there to meet children's needs. Absolute statutory duties. If a child has welfare concerns, they ought to be met, and they can be met using, a combination of the Children Act, if necessary, Mental Health Act, Community Care Act. There's a huge way to meet those needs, and actually the Howard League has been doing quite a lot of work and in discussion with various parliamentarians about whether that provision ought to be removed altogether, because as Audrey says, it becomes almost like a very difficult argument to make, because one is simultaneously seeking the court's sympathy but also saying, hang on a minute, don't do this. It's totally out of step with all the international provisions that Mike outlined in terms of the use of custody as an absolute last resort. I think that, and our quick guide deals with this point squarely, I think that there is now no argument that could be made that a child's welfare needs could be met in custody, certainly not in a YOI in the current conditions, as you've heard. To remand a child for their own welfare, when it means probably solitary confinement, it means the opposite of what we heard from Mike is set out in section 44 of the Children and Young Persons Act from the 30s, i.e. a place where they can get education and training when all they get is some rubbish, I'm quoting from a client here, worksheets under the door each day, which are nothing to do with their needs and no support with it, and no therapy and no support. As we've heard, the Supreme Court's accepted that prolonged solitary confinement, even for adults, can result in irreversible harm. So I think in the current situation, I think custody is often something that can be harmful for children, but in the current situation, I think there is a strong argument to say that it couldn't be for their own welfare, it could only be harmful.
Thank you very much, Laura. I haven't had any more questions, so anybody who is on the line who might like to pose a question, please do. I just want to emphasise the point that's been made in terms of how you might frame arguments in a bail application. So if, first of all, really, my understanding is that you may be if it's a first appearance and a child has been refused bail at the police station, you are going to be at court potentially without a youth offending team officer actually at court. So it will be a case of making phone calls and really making sure a full package of support is put in place. But I would remind everybody that if it's an overnight case, so it's not coming before a youth court, but it's being heard in an adult magistrates court, that the Magistrates Association Youth Court Protocol says that the adult magistrates court should adjourn the case to be heard by a youth court, and they should remand the child on bail, or the child should be bailed until that youth court sits. So that would be the first piece of information I give those of you who find themselves being sent to an adult magistrates court to represent a child. It may well be also that there's a huge amount of strain on the system, and that the youth offending team aren't able to assess the child, because I understand they're doing that mostly by video link. The other thing I hope it's okay to raise is, we know that the staff in the Secure Estate for Children are doing their absolute best under incredibly difficult circumstances, but one of the reasons why the education provision is not being met is not the staff in the YOIs. It's simply that the education providers are refusing to go in, or unable to, because there is an inability for external visitors to go in to youth offending institutions and they have put restrictions on what provision they're giving. They're saying they won't even mark these sheets until that they have been quarantined for a number of days. So that even where people are doing their absolute best, children really simply aren't getting the expected education and training that should be provided. So yes, I'm getting some guidance coming in from one of the participants to say that wherever possible, if people are making applications before the the Crown Court, whatever written submissions can be prepared in advance, they would be extremely valuable for the judge. Of course, not voluminous submissions, but key bite-sized pieces of information in a digestible format, and ensure where possible that you're working in conjunction with the youth offending team, so that they can support any parts of the bail application where you're putting that and those submissions that you're putting together. And we've also had a comment from Stephen Jonas to say there is a divisional court authority that the conditions in custody is a factor that benches should take into account on bail applications. Although it's an adult case, this must apply to youths. I'll get that authority and I'll share that with everyone, or Laura may have it.
I might just mention it's not specifically about bail conditions, but we have put in our briefing a little quote from Mr. Justice Chamberlain on the Chelsea Football Club case, which concerned an adult, and where the sentence was effectively, or the imprisonment was discharged on the basis that during COVID-19, not only because the person in question had potentially poor health, but also it was disproportionate to be in custody during the pandemic. I should also mention that on those general points, I think Audrey mentioned some of them in terms of the extent to which the infection, it has a far higher rate of contagion, and there's less access to healthcare generally in custody, although there's a legal duty for it to have parity with the community. The Howard League and the Prison Reform Trust together commissioned an expert report from Professor Coker, who is a public health specialist at the London School of Medicine and Tropical Hygiene, or I think I may have said that slightly wrongly, but I think you know what I mean. And that sets out all the issues about the contagion and the virus in congregate and in particular prison settings. I should be drawing this webinar to a close shortly, because I'm sure you're all anxious to get lunch, but we have had a question here about how do you get over the hurdle of where the youth offending team refuses to support bail. I don't know whether that's a first instance bail application or whether that's a renewed application for bail. I don't know whether I have the capacity to unmute you, Dapo. I'm not sure if I can find you on the screen so that I can unmute you.
Hi, Kate, can you hear me?
Yes, hi.
Hi, I think the question I ask is in the first instance bail application, where an application is made for a youth and the youth offending team refuses to support a bail package on the basis that it's not in the best interest or the welfare of the child to be granted bail.
Well, I think we've addressed the issue around welfare, that we think that balance has now shifted, given the conditions in the secure estate, and therefore it's not able to meet a child's welfare needs. I think personally it's a case of engaging with the youth offending team and using your best advocacy skills to get them on side, but it's also the second best option, which is going to be difficult at a first appearance but can be put together subsequently, is to work with a community care lawyer to get them to help put together a support package in the community that would replicate the sort of support that might be available through a youth offending team bail package. But I think it is advocacy skills to the youth offending team. And the final question that has come in from James Scobie is about the line that certain Crown Court judges are taking, that all steps are being made to protect prisoners in the secure estate. I think the point we're making here is that you want to distinguish children and how the different duties that are placed on the courts, in terms of having, the court has a duty to both have a regard to the child's welfare, and that includes having regard to provision of education and training. So even though that every step might be being put in place to segregate children so that they are at least risk of contamination, first of all, you can also refer to the Howard League report that talks about the higher risks that are in place in the prison population, but also that they can't meet the welfare duty in the secure state under the current situation. I don't know if that helps at all, and looking at those wider duties. I think at this point, unless any of the other speakers want to come in.
Very quickly, just on James's question, just to say, I mean, that's why I think using Laura's guide that she's put out in these slides, which shows statistics and actual data about what the current situation in the youth prison situation is, would be useful. Because if a prosecutor just blithely stands up and says, oh, they will manage, of course they will, they have to, and the court says, yes, we agree. I mean, if you can actually contradict that unsupported statement with evidence, it might force the court to be a little bit more forensic in how they examine such statements from prosecutors. So these resources that will be sent round would be useful.
And Laura?
Just very briefly, I think one of the things I find most compelling is the statements from the Prison Governors Association. They have been very vocal throughout this entire unprecedented crisis as to the difficulties they are facing, and the fact that they're needing to operate in a very, they are doing their best, they say they are, but no one is disputing that it is a severely restricted regime. And I think if you can show some of the press releases from the prison governors, which are on their own website, and say even the Prison Governors Association are desperate for the prison population to be reduced, then I think that's quite a powerful point to make.
Thank you, Laura. So thank you to Michael, to Audrey and to Laura for joining us today and sharing their expertise and knowledge. I hope you agree with me that it's been a really informative discussion. Thank them very much for their time, and thank you all as participants for joining us today. You will receive a follow-up email from Garden Court Chambers with the slides and a link to a video of this webinar. And please do join us again next week when there will be the next seminar, which will be looking at the challenges for children appearing in court over video link and how we can represent them to the best of our ability. And of course, final plug for the book, there is a significant discount available for both a hard copy and a digital copy of the book, Youth Justice, Law and Practice, that you may very well find helpful in your future work. Thank you very much for joining us today, and goodbye.